page 23.1, Chapter 23, the Judiciary in India, the Supreme Court, the High Courts. 1. The Supreme Court of India. 1a. Introductory. Chapter 4, Roman 4 of Part Roman 5, from Articles 124 to 147 of the Constitution, deal with the Union Judiciary, which largely relates to the Supreme Court of India. Article 124 of the Constitution says that there shall be a Supreme Court of India consisting of a Chief Judge and other judges whose number is prescribed by the Parliament through law passed from time to time. In 1950, the Supreme Court of India consisted of 1 Chief Judge and 7 judges, that is total 8. This number increased to 11 in 1956, 14 in 1960, 18 in 1978 and 26 in 1986. The Supreme Court at present consists of 1 Chief Judge and 25 other judges. Each judge, including the Chief Justice, has a tenure until he attains the age of 65 years. He can resign or can be removed as per clause 4 capital A of Article 124, which reads, "A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament, supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of the House present, and voting has been presented to the President in the same session, for which removal on the ground of proved misbehavior or incapacity." Clause 3 of the article prescribes the qualifications for appointment as a judge as a citizen of India, and A. has been for at least 5 years a judge of High Court or 2 or more such courts in succession, or B. has been for at least 10 years an advocate of a High Court or 2 or more such courts in succession, or C. is, in the opinion of the President, a distinguished jurist. A judge who has served in the Supreme Court is debarred to plead in any court within the territory of India after retirement. The judges of the Supreme Court are paid salaries and are entitled to such privileges as are determined by Parliament by law passed from time to time, within bracket Article 125 bracket closed. The Supreme Court came into force being, I repeat, the Supreme Court came into being on January 28, 1950, and the inauguration took place in the Chamber of Prince in the Parliament. The appointment of judges has become an important issue over the years. Indeed, the Chief Justice is appointed by the President after consultation with judges of the Supreme Court and High Courts as he deems necessity. Chapter 23, the Judiciary in India, the Supreme Court, the High Court. Page 23.2. The other judges are appointed by the President after consultation with the Chief Justice and other judges of the Supreme Court and High Courts as he deems necessary. What has become an issue is the word within bracket within inverted comma consultation and its implications. The Supreme Court has itself given different interpretations of the word within inverted comma consultation. In the first judge's case, within bracket 1982, within inverted comma consultation was understood as within inverted comma exchange of views, inverted comma close, and not concurrence within inverted comma. While in the second judge's case, within bracket 1993 bracket closed, the Supreme Court held the word within inverted comma consultation to mean concurrence, and that the advice given by the Chief Justice is binding on the President in matter relating to the appointment of judges of the Supreme Court, making it clear that the Chief Justice, while giving advice to the President, would consult 2 of his senior-most colleagues. In the third judge's case, within bracket 1998, the Supreme Court held the view that the consultation process adopted by the Chief Justice would require, within inverted comma, consultation of plurality judges, bracket inverted comma close, that is the Chief Justice needs to consult a collegium of 4 senior-most judges of the Supreme Court, and if 2 of them give an adverse opinion, the Chief Justice need not send the recommendation to the government. All these has necessitated the establishment of a National Judicial Commission to help appoint judges of the Supreme Court. Page 23.2, Chapter 23, the Judiciary in India, the Supreme Court, the High Courts. 1. The Supreme Court of India, Chief Justice of India. This is described in a table. In the horizontal column, there are 2 heads, name and tenure. I read the name and against the tenure of each name. Under the head name, Horilal J. Kania, tenure 26 January 1950 to 6 November 1951. M. Patanjali Shastri, tenure 7th November 1951 to 3rd January 1954. Name Meherchand Mahajan, tenure 4th January 1954 to 22nd December 1954. Name B.K. Mukherjee, tenure 23rd December 1954 to 31st January 1956. Name S.R. Das, 1st February 1956 to 30th September 1959. Bhubaneswar Prasad Sinha, tenure 1st October 1959 to 31st January 1964. P.B. Gajendra Gatkar, tenure 1st February 1964 to 15th March 1966. A.K. Sarkar, tenure 16th March 1966 to 29th June 1966. K. Subbarao, tenure 30th June 1966 to 11th April 1967. Name K. N. Wanchu, tenure 12th April 1967 to 24th February 1968. Name M. Hidayatullah, tenure 25th February 1968 to 16 December 1970. Name I.C. Shah, tenure 17 December 1970 to 21st January 1971. Name S.M. Sikri, 22nd January 1971 to 5th April 1973. Name A.N. Rai, tenure 26th April 1973 to 27th January 1977. Name M.H. Beg, 28th January 1977 to 21st February 1978. Name Y.V. Chandrachud, tenure 22nd February 1978 to 11th July 1985. Name Prafulla Chandra Nadvarlal Bhagavati, tenure 12th July 1985 to 20th December 1986. Name R.S. Pathak, tenure 21st December 1986 to 18th June 1989. Name E.S. Venkatramaya, tenure 19th June 1989 to 17th December 1989. S. Mukherjee, tenure 18th December 1989 to 25th September 1990. Ranganath Mishra, tenure 26th September 1990 to 24th November 1991. K.N. Singh, tenure 25th November 1991 to 12th December 1991. Name M.H. Kania, tenure 13th December 1991 to 17th November 1992. I.M. Sharma, 18th November 1992 to 11th February 1993. M.N. Venkatchalia, tenure 12th February 1993 to 24th October 1994. Name A.M. Ahmadi, tenure 25th October 1994 to 24th March 1997. Name J.S. Verma, 25th March 1997 to 17th January 1998. Name M.M. Punchi, tenure 18th January 1998 to 9th October 1998. Name A.S. Anand, 10th October 1998 to 31st October 2001. S.P. Bharucha, 1st November 2001 to 5th May 2002. B.N. Kirpal, 6th May 2002 to 7th November 2002. G.B. Patanayak, tenure 8th November 2002 to 18th December 2002. Name V.N. Khare, 19th December 2002 to 1st May 2004. S. Rajendra Babu, name tenure 2nd May 2004 to 31st May 2004. Name R.S. Lahuti, tenure 1st June 2004 to 31st October 2005. Y.K. Sabarwal, tenure 1st November 2005 to 13th January 2007. Name K.G. Balakrishnan, 14th January 2007 till the publication of this book. Chapter 23, the Judiciary in India, the Supreme Court, the High Courts. The Judges Enquiry Act 1965 regulates the procedure relating to the removal of a judge of the Supreme Court, and the procedure is 1. A removal motion signed by 100 members in the case of Lok Sabha or 50 members in the case of Rajya Sabha (close) is to be given to the Speaker / Chairman. 2. The Speaker / Chairman may admit the motion or refuse to admit it. 3. If it is admitted, then the Speaker / Chairman is to constitute a 3-member committee to investigate into the charges. 4. The committee should consist of A. The Chief Justice or a judge of the Supreme Court I repeat, A. The Chief Justice or a judge of the Supreme Court. B. A Chief Justice of a High Court. And C. A distinguished jurist. 5. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. 6. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. 7. Finally, the President passes an order removing the judge. No Supreme Court judge has been impeached so far. The first and the only case of impeachment is that of Justice V. Ramaswamy of Supreme Court (1991 to 1993). Though the Enquiry Committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress party abstained from voting. 1b. Jurisdiction of the Supreme Court. The Supreme Court has original, appellate and advisory jurisdiction. 1. Original jurisdiction. It has exclusive, under Article 131, original jurisdiction over any dispute between the Government of India and one or more states, or between the Government of India and any state or states on one side and one or more states on the other, or between two or more states, if and insofar as the dispute involves any question whether the law or of fact closed, on which the existence or extent of a legal right depends. In addition, Article 32 of the Constitution grants an extensive original jurisdiction to the Supreme Court in regard to enforcement of fundamental rights. It is empowered to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, to enforce them. 2. Appellate jurisdiction. The appellate jurisdiction of the Supreme Court can be invoked by a certificate granted by the High Court concerned under Article 132(1), 133(1) and 134 of the Constitution in respect of any judgment, decree or final order of a High Court in both civil and criminal cases involving substantial questions of law as to the interpretation of the Constitution. The Supreme Court can also grant special leave to appeal for a judgment or order of any non-military Indian court. Parliament has the power to enlarge the appellate jurisdiction of the Supreme Court and has exercised this power in case of criminal appeals by enacting the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970. Judiciary in India, the Supreme Court, the High Courts, page 23.3, 1b, jurisdiction of the Supreme Court. Continued. Appeals also lie to the Supreme Court in civil matters if the High Court concerned certifies that a. that the case involves a substantial question of law of general importance, and b. that in the opinion of the High Court the said question needs to be decided by the Supreme Court. In criminal cases, an appeal lies to the Supreme Court if the High Court a. has on appeal reversed an order of acquittal of an accused person and sentenced him to death or to imprisonment for life or for a period of not less than 10 years, or b. has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused and sentenced him to death or to imprisonment for life or for a period of not less than 10 years, or c. certified that the case is a fit one for appeal to the Supreme Court. Parliament is authorized to confer on the Supreme Court any further powers to entertain and hear appeals from any judgment, final order or sentence in a criminal proceedings of a High Court. 3. Advisory jurisdiction. The Supreme Court has special advisory jurisdiction in matters which may specifically be referred to it by the President of India under Article 143 of the Constitution. The President is not bound to accept the advice. Some of the cases where the advice of the Supreme Court was sought included Delhi Laws Act (1954), Kerala Education Bill (1958), Birubari Union (1960), Customs Act (1963), Special Courts Bill (1978), Jammu and Kashmir Resettlement Act 1982, Kaveri Water Dispute Tribunal (1992), Ram Janmabhoomi Case 1994. 4. The Supreme Court has the power to grant special leave to appeal from any judgment by any court (Article 136). 5. The Supreme Court is empowered to review its own judgment under Article 137. Under Article 129 and 142 of the Constitution, the Supreme Court has been vested with power to punish anyone for contempt of any law court in India itself. The Supreme Court performed an unprecedented action when it directed a sitting minister of the state of Maharashtra to be jailed for 1 month on a charge of contempt of court on May 12, 2006. This was the first time that a serving minister was ever jailed. The Chapter 23, the Judiciary in India, the Supreme Court, the High Courts, page 23.4, 1b, jurisdiction of the Supreme Court. Continued. Judicial review. Judicial review is the power through which the judiciary examines the constitutionality of a legislative act and or executive order. If on examination it is found that there has been a violation of the Constitution, the judiciary declares it to be unconstitutional and invalid. Though the words within inverted comma judicial review inverted comma close has now here been used in the Constitution, numerous provisions within brackets such as Articles 13, 32, 131, 132, 133, 134, 226, 246, etc. bracket close, explicitly confer the power of the judicial review on the Supreme Court. The Supreme Court has used the power of judicial review in various cases. As for example, the Goloknath case within bracket 1967, the bank nationalization case within bracket 1970, the Privy Purchase abolition case within bracket 1971, the Keshavananda Bharati case within bracket 1973, the Minerva Mills case within bracket 1980, and so on. When the judicial review power is exercised, the following three grounds are referred to by saying that the law or the order A infringes the fundamental rights within bracket part 3, B is outside the competence of the authority which has framed it, and C it is repugnant to the Constitution is repugnant to the constitutional provisions. The Constitution seeks to ensure the independence of Supreme Court judges in various ways. Judges are generally appointed on the basis of seniority and not on political preference. A judge of the Supreme Court cannot be removed from office except by an order of the President passed after an address in each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members present and voting, and presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. The salary and allowances of the judges of a judge of the Supreme Court cannot be reduced after appointment. A person who has been a judge of the Supreme Court is debarred from practicing in any court of law or before any other authority in India. Chapter 23, the Judiciary in India, the Supreme Court, the High Court, page 23.5. 1C. Position of the Supreme Court of India. The Supreme Court of India, being the highest judicial organ, is an important institution in our polity. Over the year, it has proved its worth by being the custodian of the Constitution, protector of our federal system, and also the defender of the fundamental rights of our people. There has been a time which the legislature and the judiciary had come into conflict, from Goloknath case within bracket 1967 to the Minerva Mills case within bracket 1980, from where certain features of our polity have emerged. The judiciary, notwithstanding its judicial activism, has admitted Parliament's power to amend the Constitution. The Parliament has also realized that it has to work within the basic framework of the Constitution. The balance has been struck. Indeed, the Supreme Court of India has been able to attain and keep its grandeur. It is not as powerful as the American Supreme Court. The American Supreme Court has empowered itself through what is called within bracket due process of law within inverted comma clause, which has given wide scope of power to the American Supreme Court, including the power to protect the rights of the people and the Constitution itself. The Indian Supreme Court works within what has been described as within bracket procedure established by law bracket within inverted comma procedure established by law inverted comma clause, which has relatively restricted the scope of power. The American Supreme Court goes by the law as well as its spirit, while the Indian Supreme Court goes more by law than by its spirit. 2. The High Courts in the States. Chapter Roman 5 or Part Roman 6 from Article 214 to 231 deal with High Courts in the States. Article 214 says that there shall be a High Court for each state, though some states together may have one High Court. Within bracket Guwahati High Court, for example, has its jurisdiction over the states of Arunachal Pradesh, Assam, Manipur, Meghalaya, Nagaland, Tripura, Mizoram. Punjab and Haryana High Court has its jurisdiction, and Haryana High Court Punjab and Haryana High Court has its jurisdiction over the states of Punjab and Haryana. bracket closed. Among the union territories, Delhi alone has a high court. Other union territories are attached to their neighboring states. Like the Supreme Court of India, each high court is also a court of record within bracket Article 215, and as such has the power to punish the contempt of the court. Each high court, Article 216 says, consists of a chief judge and such other judges as the president may from time to time deem it necessary to appoint. Article 217 prescribes the appointment tenure qualifications. It reads thus: 1. Every judge of a high court shall be appointed by the president by warrant under his hand and sealed after consultation with the Chief Justice of India, the Governor of the state, and in the case of appointment of a judge other than the Chief Judge, the Chief Justice of the High Court, and shall hold office in the case of an additional or acting judge as provided in Article 224 and in any other case until he attains the age of 62 years. Provided that A judge may by an application written in his hand addressed to the President resign from his office. B. A judge may be removed from his office by the Parliament in the manner prescribed in Clause 4 of Article 124 of the removal of a judge of the Supreme Court. Chapter 23, the Judiciary in India, the Supreme Court, the High Courts. Page 23.6. To the High Courts in the States continued. C. The office of a judge shall be vacated by his being appointed by the President to be a judge of the Supreme Court or by his being transferred by the President to any other High Court within the territory of India. 2. A person shall not be qualified for appointment as a judge of High Court unless he is a citizen of India and A. has for at least 10 years held in a judicial office in the territory of India, or A. B. has for at least 10 years has been advocate of a High Court of 2 or more such courts in succession. The Calcutta High Court is the oldest High Court in the country, established on July 2, 1862. The High Courts, which handle a large number of cases of a particular region, have permanent benches within bracket or a bench of the court established there. Benches are also present in states which come under the jurisdiction of a court outside its territorial limits. The smaller states with few cases may have circuit benches established. Circuit benches within bracket known as circuit courts in some parts of the world bracket closed are temporary courts which hold proceedings for a few selected months in a year. Thus, cases built up during the interim period are judged when the circuit court is in session. Now, High Court's jurisdiction given in a table. In the horizontal column, the heads are court name, established, act established, jurisdiction, seat. Under court's name, Allahabad High Court, established 11th June 1866. Acts established, High Court Act 1861. Jurisdiction, Uttar Pradesh. Seat, Allahabad. Court name, Andhra Pradesh High Court. Established 5th July 1954. Act established, Andhra State Act 1953. Jurisdiction, Andhra Pradesh. Seat, Hyderabad. Court name, Bombay High Court. Established 14th August 1862. Act established, High Court Act 1861. Jurisdiction, Maharashtra, Goa, Dadra, Nagar Haveli, Daman and Diu. Seat, Mumbai. Court name, Calcutta High Court. Established 2nd July 1862. Act established, High Courts Act 1861. Jurisdiction, West Bengal, Andaman and Nicobar Islands. Seat, Calcutta. Court name, Chhattisgarh High Court. Established 11th July 2000. 11th January, 11th January 2000. Act established Madhya Pradesh Reorganization Act 2000. Jurisdiction Chhattisgarh. Seat Bilaspur. Court name Delhi High Court. Established 31st October 1966. Act established Delhi High Court Act 1966. Jurisdiction National Capital Territory of Delhi. Seat New Delhi. Court name Guwahati High Court. Established 1st March 1948. Act established Government of India Act 1935. Jurisdiction Arunachal Pradesh, Assam, Manipur, Meghalaya, Nagaland, Tripura, Mizoram. Seat Guwahati. Court name Gujarat High Court. Established 1st May 1960. Act established Bombay Reorganization Act 1960. Jurisdiction Gujarat. Seat Ahmedabad. Court name Himachal Pradesh High Court. Established 1971. Act established State of HP Act 1970. Jurisdiction Himachal Pradesh. Seat Shimla. Court name Jammu and Kashmir High Court. Established 20th August 1943. Act established letters patent issued by the Maharaja of Kashmir. Jurisdiction Jammu and Kashmir. Seat Srinagar and Jammu. Court name Jharkhand High Court. Established 2000. Act established Bihar Reorganization Act 2000. Jurisdiction Jharkhand. Seat Ranchi. Court name Karnataka High Court. Established 1884. Act established Mysore High Court Act 1884. Jurisdiction Karnataka. Seat Bangalore. Court name Kerala High Court. Established 1956. Act established States Reorganization Act 1956. Jurisdiction Kerala Lakshadweep. Seat Kochi. Court name Madhya Pradesh High Court. Established 2nd January 1936. Act established Government of India Act 1935. Jurisdiction Madhya Pradesh. Seat Jabalpur. Court name Madras High Court. Established 15th August 1862. Act established High Court Act 1861. Jurisdiction Tamil Nadu Pondicherry. Seat Chennai. Court name Orissa High Court. Established 3rd April 1948. Act established Orissa High Court Order 1948. Jurisdiction Orissa. Seat Cuttack. Court name Patna High Court. Established 2nd September 1916. Act established Government of India Act 1915. Jurisdiction Bihar. Seat Patna. Court name Punjab and Haryana High Court. Established 8th November 1947. Act established High Court within bracket Punjab Order 1947. Jurisdiction Punjab, Haryana, Chandigarh. Seat Chandigarh. Rajasthan High Court. Established 21st June 1949. Act established Rajasthan High Court Ordinance 1949. Jurisdiction Rajasthan. Seat Jodhpur. Court name Sikkim High Court. Established 1975. Act established 38th Amendment. Jurisdiction Sikkim. Seat Gangtok. Court name Uttaranchal High Court. Established 2000. Act established UP Reorganization Act 2000. Jurisdiction Uttaranchal. Seat Nainital. The judges of the High Courts are paid salaries and are entitled for privileges as are determined by the Parliament through law. The jurisdiction of the High Court can be summed up as follows. 1. Original. The High Court hears all disputes. A. Relating to matters of admiralty, will, marriage, company laws, contempt of court. B. Relating to the elections of Parliament and the state legislature. C. Relating to revenue matters. D. Relating to enforcement of fundamental rights. 2. Writ. The High Court has the power to issue writs such as habeas corpus, mandamus, prohibition, quo warranto, certiorari, within bracket Article 226. 3. Appellate civil appeals from the orders and judgments of the district courts, additional courts, criminal appeals in which decisions the sentence has been more than 7 years. Death sentence have to be confirmed by the High Court of the lower courts, gives such punishment where the lower court itself certifies that the appeal against its judgment can be made. 4. Control over the subordinate courts. The High Courts has the power to superintend over all the courts and tribunals with regard to the compliance of rules and procedures and also with regard to service conditions. 5. Judicial review. The High Court has the power to examine the constitutionality of the law or executive order and declare the same void if it is against the Constitution. The 42nd Amendment within bracket 1976 had restricted such jurisdiction to the state laws within its purview, but the 43rd Amendment within bracket 1977 restored the jurisdiction of the High Court to include the union laws and orders as well. Page 23.7. Chapter 23, the Judiciary in India, the Supreme Court, the High Court. 3. Subordinate courts. The Supreme Court and functions of subordinate courts are more or less uniform throughout the country. Designations of courts connote their functions. These courts deal with all disputes of civil or criminal nature as per the powers conferred on them. They have been derived principally from two important codes prescribing procedures, the Code of Civil Procedure 1908 and the Code of Criminal Procedure 1973, and further strengthened by local statutes as per direction of Supreme Court in writ petition NWP within bracket civil 1022/1989. In the All India Judges Association case, a uniform designation has been brought about in the subordinate judiciaries, judicial officers all over the country, namely the district or additional district judges, civil judge within bracket senior division and civil judge within bracket junior division on the civil side, and on criminal side session judge, additional session judge, chief judicial magistrate and judicial magistrate etc. as laid down in the CRPC. Under Article 325 of the Constitution of India, the administrative control over the members of subordinate judiciary service vests with the concerned High Court. Further, in exercise of powers conferred under proviso into Article 309, read with Article 233 and 234 of the Constitution, the state government shall frame rules and regulations in consultation with the High Court, exercising jurisdiction in relation to such state. The matters of the state judicial services are governed by these rules and regulations. The next set of courts is described as courts of district and session judge, which also include courts of additional judge, joint judge or assistant judge. The court of the district and session judge at district level is the principal court of original jurisdiction. In addition, there are courts known as small causes courts. These are set up either under the provisions under the Provisional Small Causes Act at the district level or under the Presidency Town Small Causes Courts Act in Presidency/Metropolitan Towns. The Family Courts etc. 1984 aims at promoting conciliation in and securing speedy settlement of dispute relating to marriage and family affairs and related matters. It envisages that courts shall be set up in a city or town with a population of more than 10 lakh and at such other places as the state government may deem necessary. Family courts have been set up in Andhra Pradesh 7, Assam 1. I repeat, family courts have been set up in Andhra Pradesh 7, Assam 1, Bihar 2, Karnataka 5, Kerala 5, Maharashtra 16, Manipur 1, Odisha 2, Pondicherry 1, Punjab 2, Rajasthan 5, Sikkim 1, Tamil Nadu 6, Uttar Pradesh 16 and West Bengal 1. Besides necessary notifications extending the jurisdiction of the Family Courts Act have been issued by the Government of India in respect of Haryana, Madhya Pradesh and Union Territory of Andaman and Nicobar Islands. Chapter 23, the Judiciary in India, the Supreme Court, the High Courts. Roman 4, Lok Adalat, page 23.8. Lok Adalat within People's Courts established by the government settles dispute through conciliation and compromise. The first Lok Adalat was held in Chennai in 1986. Lok Adalat assesses the cases which could be settled by conciliation and compromise and pending in the regular courts within their jurisdiction. The Lok Adalat is presided over by a sitting or retired judicial officer as the chairman with two other members, usually a lawyer and a social worker. There is no court fee. If the case is already filed in the regular court, the fee paid will be refunded if the dispute is settled at the Lok Adalat. The procedural laws and the Evidence Act are not strictly followed while assessing the merits of the claim by the Lok Adalat. Main condition of the Lok Adalat is that both parties in dispute should agree for settlement. The decision of the Lok Adalat is binding on the parties of the dispute and its order is capable of capable of execution through legal process. No appeal lies against the order of the Lok Adalat. Lok Adalat is very effective in settlement of money claims. Dispute like partition suits, damages and matrimonial cases can also be easily settled before Lok Adalat as the scope for compromise through an approach of give and take is high in these cases. Lok Adalat is a boon to the litigant people where they can get their disputes settled fast and free of cost. Lok Adalats have proved to be an effective mechanism for resolution of disputes through conciliatory methods. Up to December 31, 1997, about 17,633 Lok Adalats have been held in different parts of the country, where about 68.86 lakh cases were settled in about 3,49,710 motor vehicles accident claims cases. Compensation amounting to over rupees 1,160.07 crore was awarded. Under the Legal Services Authorities Act, Lok Adalat has been given the status of a civil court, and every award made by Lok Adalats is final and binding on all parties, and no appeal lies to any court against its award. Exercise 23, the Judiciary in India, the Supreme Court, the High Court. Page 23.9, Roman 5, Legal Aid and Public Interest Litigation. Article 39A of the Constitution provide for free legal aid to the poor and weaker sections of the society. The Legal Services Authorities Act 1987 within bracket as amended by the Act of 1994 bracket closed, which came into force on November 9, 1995, aims at establishing a nationwide network for providing free and comprehensive legal services to the weaker sections. National Legal Services Authority within bracket capital NALSA NALSA bracket closed has been set up for implementing and monitoring legal and programs in the country. The Supreme Court Legal Services Committee has been constituted under the Act. In every High Court also, the High Court Legal Services Committees are being established to provide free legal aid to the eligible persons in legal matters coming before the High Courts. The Legal Service Authorities Act also provides for construction of the State Legal Services Committees, High Court Legal Services Committees, District Legal Services Committees, and Taluk Legal Services Committees. Under the Legal Services Authorities Act, every citizen whose annual income does not exceed rupees 9,000 is eligible for free legal aid in cases before subordinate courts and high courts. In cases before the Supreme Court, the limit is rupees 12,000. The limit can be increased by the state governments. Limitation as to the income does not apply in case of persons belonging to the scheduled castes, scheduled tribes, women, children, handicapped, etc. The legal and programs adopted by NALSA include promoting of legal literacy, setting up of legal aid clinics in universities and law colleges, training of paralegals and holding of legal and camps and lok adalats. The government has sanctioned rupees 4 crore as grant in aid for NALSA for 1998-99 for allocating funds to the state, district authorities, etc. The NALSA is also monitoring and evaluating the implementation of the legal aid programs in the country. Up to December 1997, about 23.88 lakhs persons were benefited through court-oriented legal and programs provided by the state legal aid and advice boards / state legal services. Authorities, I repeat, up to December 1997, about 23.88 lakh persons were benefited through court-oriented legal aid programs provided by the state legal aid and advice boards / state legal services authorities. Of them, 3.73 lakh persons belong to the scheduled castes, about 2.14 lakhs to the scheduled tribes, 2,40,485 were women, and 8,578 were children. Public interest litigation in Indian law means litigation from the protection of public interest. It is litigation introduced in a court of law, not by the aggrieved party, but by the court itself or by any other private party. It is not necessary for the exercise of the court's jurisdiction that the person who is the victim of the violation of its or her right should be personally approach the court. Such cases may occur when the victim does not have the necessary resources to commence litigation, or his freedom to move court has been suppressed or encroached upon. The court can itself take cognizance of the matter and proceed suo motu, or cases can commence on the petition of any public-spirited individual. Prior to the 1980s, only the aggrieved party could approach the courts for justice. However, post 1980s and after the emergency era, the apex court decided to reach out in the people, and hence it devised an innovative way wherein a person or a civil society group could approach the Supreme Court seeking legal remedies in cases where public interest is at stake. Justice P. N. Bhagwati and Justice V. R. Krishna Iyer were among the first judges to admit PILs in the court. Filing a PIL is not as cumbersome as any other legal case, and there have been instances when even letters and telegrams addressed to the court have been taken up as bills and heard by the court. Chapter 23, the Judiciary in India, the Supreme Court, the High Courts, page 23.10, Roman 6, Law Commission of India. The 17th Law Commission was reconstituted on 1st September 2003 for a period of 3 years with Honorable Mr. Justice M. Jagannath Rao as its chairman, Mr. R.L. Misra, former Law Secretary, has been appointed its Vice Chairman with effect from 31st March 2006, and Dr. D.P. Sharma as its Member Secretary with effect from 31st March 2006. The terms of reference of Law Commission are: A. Review / repeal of obsolete laws. 1. To identify laws which are no longer needed or relevant and can immediately repealed. 2. To identify laws which are in harmony with the existing climate of economic liberalization which need the change. 3. To identify laws which require changes or amendments and to make suggestions for their amendment. 4. To consider in a wider perspective the suggestions for revisions or amendment given by expert groups in various ministries within departments with a view to coordinating and harmonizing them. 5. To consider references made to it by ministries departments in respect of legislation having bearing on the working of more than one ministry department. 6. To suggest suitable measures for quick redressal of citizens' grievances in the field of law. B. Law and poverty. 1. To examine the laws which affect the poor and carry out post-audit for socio-economic legislation. 2. To take all such measures as may be necessary to harness law and the legal process in the service of the poor. C. To keep under review the system of judicial administration to ensure that it is responsive to the reasonable demands of the time, and in particular to secure: 1. Elimination of delays, speedy clearance of arrears, and reduction in costs so as to secure quick and economical disposal of cases without affecting the cardinal principle that decisions should be just and fair. 2. Simplification of procedure to reduce and eliminate technicalities and devices for delay so that it operates not as an end in itself but as a means of achieving justice. D. To examine the existing laws in the light of directive principles of state policy and to suggest ways of improvement and reform, and also to suggest such legislation as might be necessary to implement the directive principles and to attain the objectives set out in the preamble to the Constitution. E. To revise the central acts of general importance so as to simplify them and to remove anomalies, ambiguities and inequities. F. To recommend to the government measure of bringing the statute book up to date by repealing obsolete laws and enactments or parts thereof which have outlived their utility. G. To consider and to convey to the government's views on any other subject relating to law and judicial administration that may be referred to by the government through Ministry of Law and Justice within bracket Department of Legal Affairs bracket closed. Various subjects were taken up by the Commission suo motu in view of the importance of the issues, while some subjects were taken up on reference from the Government / Supreme Court of India. The Commission has so far submitted within 195 reports during 2005 until 2006. The 17th Law Commission has submitted 4 reports. Chapter 23, Judiciary in India, the Supreme Court, the High Courts. Exercises. Exercise 16. The Goloknath case is decided A. that the Parliament has no power to abrogate the fundamental rights. B. that the Parliament has the power to amend the fundamental rights. C. that the Parliament has the power to amend the Constitution. D. that the Parliament has the power to restrict right to property. The correct answer is A. that the Parliament has no power to abrogate the fundamental rights. Exercise 17. Which of the following decision was related to the basic structure doctrine? A. the Goloknath case. B. the Keshavananda Bharati case. C. the A.K. Gopalan case. And D. the Maneka Gandhi case. The correct answer is B. the Keshavananda Bharati case. Exercise 18. Which of the following cases is not an example of judicial activism? A. Goloknath case. B. Gopalan case. C. Maneka Gandhi case. And D. none of the above. The correct answer is A. Goloknath case. Exercise 19. Match list 1 with list 2 with regard to its number of judges in the Supreme Court and select the correct court. In the horizontal column, the heads are list 1 and list 2. Under the head list 1, in the vertical column, against serial number capital A 1952, capital B 1960, capital C 1978, capital D 1986. And under the head list 2, in the vertical column against list 1 26, list 2 8, serial number against the against the head list 2, in the vertical column against serial number 1 26, serial number 2 8, serial number 3 14, serial number 4 18. The court, in the horizontal column, the heads are capital A, capital B, capital C, capital T. Under the head capital A, in the vertical column against serial number A2, B2, C4 and D4. D. Under the head capital B, in the vertical column against serial number A3, B3, C2, D2. Under the head capital C, against serial number A4, B1, C1, D3. Under the head capital D, against serial number A1, B2, B4, C3 and D1. The correct answer is A, that is under serial number capital A, 2, that is under serial number capital A, that is 1962. Under serial number capital A, that is 1952. 2, that is 8. Under serial number capital B, 1960. 3, that is 14, under serial number capital C, 1978. 4, that is 18, under serial number capital G, 1986. 1, that is 26. Exercise 20. A judge of High Court can be removed from office during his tenure by A. the governor if the state legislature passes a resolution to this effect by 2/3 majority. B. the president on the basis of a resolution passed by the parliament by 2/3 majority. C. the Chief Justice of the Supreme Court on the recommendation of the parliament. D. the Chief Justice of the High Court on the recommendation of the state legislature. The correct answer is B. the President on the basis of a resolution passed by the Parliament by 2/3 majority. Exercise 21. Restriction of the writ jurisdiction of the High Courts under Article 226 of the Constitution is only possible through A. an amendment of the Constitution passed by 2/3 majority of members present and voting and a majority of the total membership of each House of Parliament. B. an amendment of the Constitution passed by a simple majority of members present and voting in both Houses of Parliament. C. an amendment of the Constitution passed by 2/3 majority of members passed or members. I repeat, C. an amendment of the Constitution passed by 2/3 majority of members present and voting and a majority of the total membership of each House of Parliament together with the ratification of half of the state legislatures. D. an amendment of the Constitution passed by the 2/3 majority of members present and voting and a majority of the total membership of each House of Parliament together with the ratification of three quarters of the state legislature. Which of the following is the correct answer is C, that is an amendment of the Constitution passed by the 2/3 majority of members present and voting and a majority of the total membership of each House of Parliament together with the ratification of half of the state legislatures. Exercise 22. Which of the following is main jurisdiction of the High Court of the State? 1. Original jurisdiction, 2. Appellate jurisdiction, 3. Supervisory jurisdiction, and 4. Advisory jurisdiction. A. 1, 2 and 3, B. 2, 3 and 4, C. 1, 3 and 4, D. 1, 2 and 4. The correct answer is A, that is 1, 2 and 3. The correct answer is A, that is 1. Original jurisdiction, 2. Appellate jurisdiction, 3. Supervisory jurisdiction. Chapter 23, the Judiciary in India, the Supreme Court, the High Court, page 23.13. Exercise 23. In the statements within inverted comma, the legislature of any state in India X, the jurisdiction of the High Court in the state X stands for A. Within inverted comma, can increase, B. can restrict, C. can abolish, and D. cannot increase, restrict or abolish. The correct answer is D, that is cannot increase, restrict or abolish. Exercise 24. Who was the first woman judge of the Supreme Court of India? A. Fatma Bibi, B. Sujata Manohar, C. Ruma Pal, D. none of the above. The correct answer is A, that is Fatma Bibi. Exercise 25. The High Courts as principal courts can try cases such as A. those between the Union and the states, B. those between states themselves, C. those relating to death punishment, D. those relating to Union and one state on the one hand and the one or more states on the other. The correct answer is C, that is those relating to death punishment. Exercise 26. The judges of the High Court are appointed by A. Governor of the concerned state, B. President of India, C. Chief Justice of India, D. India Parliament, Indian Parliament. That one answer is B, that is President of India. Exercise 27. Which of the following high courts is the oldest in India? A. The Calcutta High Court, B. the Allahabad High Court, C. the Bombay High Court, and D. the Madras High Court. The correct answer is A, that is the Calcutta High Court. With 28. Match list 1 with list 2. In the horizontal column, the heads are list 1 and list 2. Under list 1, list 1 as head in the vertical column against A. Again, in the vertical column against serial number A, article 214, against serial number B, article 215, against serial number C, article 216, against serial number D, article 225. Under list 2 as head, in the vertical column against serial number 1, jurisdiction, serial number 2, provision of High Court, against serial number 3, court of record, against serial number 4, composition of High Courts. A court in the horizontal column, the heads are capital A, B, capital C, capital D. Under the head capital A in the vertical column against serial number A2, B2, C4 and D4. Under the head capital B against serial number A in the vertical column 3, B3, C3 and D3. Under the head capital C in the vertical column against serial number A4, B1, C1 and D2. Under the head capital D against serial number in the vertical column against serial number A1, B4, C2 and D1. The correct answer is A. That is under capital A, article 214, 2, that is provision of High Court. Under capital B, article 215, 3, that is court of record. Under the head capital C, that is article 216, 4, that is composition of High Court. Under the head capital D, 1, that is jurisdiction. Chapter 23, the Judiciary in India, the Supreme Court, the High Courts. Exercise number 29. The High Court has the power to issue writs under A 224, under B 225, C 226 and D 227. The correct answer is C, that is 226. Exercise 30. The district judges are appointed by A. President, B. Governor, C. Chief Minister and D. Deputy Commissioner. The correct answer is B, that is Governor. Exercise 31. The doctrine of basic structure A is strictly in accord with the principle of within invert comma procedure established by law invert comma close. B is consistent with the principle of the due process of law. C accepts the theory that the legislature is the supreme lawmaking authority. D assumes the power of judging the wisdom of the sovereign legislature. The correct answer is A, is strictly in accord with the principles of within invert comma procedure established by law invert comma close. Exercise 32. Consider the following statements. A public interest petition can be accepted when it is moved by 1. An individual when his interest is affected. 2. A group when the interest of its members is affected. 3. An individual or a group when the interest of the population in general are affected. 4. An individual with the help of a group for the safeguard of that group's interest. Which of these statements is correct? 1. A. 1, 2, 3 and 4. B. 1, 2 and 3. C. 3 alone and D. 4 alone. The correct answer is C, that is 3 alone. An individual or a group when the interest of the population in general are affected. Chapter 23, the Judiciary in India, the Supreme Court, the High Court. The page number 23.15, exercise number 33. Who is the first law officer of the Government of India? A. Chief Justice of India. B. Union Law Minister. C. Attorney General of India. And D. Law Secretary. The correct answer is C, that is Attorney General of India. Exercise 34. Which one of the following is true about the Attorney General of India? A. He shall have the right of audience in all the courts within the territory of India. B. He shall perform his duties only in the Supreme Court. C. He enjoys a fixed tenure. D. The President appoints a person who is qualified to be a judge of a High Court to be the Attorney General of India. The correct answer is A. He shall have the right of audience in all the courts within the territory of India. Exercise 35. Which of the following statements is correct? A. The Constitution clearly lays down what its basic structure is. B. The Supreme Court has elaborately defined the basic structure of the Constitution. C. The Law Commission of India, with the help of Attorney General of India, has defined that basic structure of the Constitution. D. Neither the Supreme Court nor the Parliament have defined the basic structure of the Constitution. The correct answer is B. The Supreme Court has elaborately defined the basic structure of the Constitution. Exercise 36. The doctrine of within inverted comma prospective overruling inverted comma clause was adopted by the Supreme Court of India in the case of A. Champakam Dorariajan versus State of Madras. B. Goloknath versus State of Punjab. C. Kesavananda Bharati versus State of Kerala. And D. Kehar Singh versus Union of India. The correct answer is B. That is Goloknath versus State of Punjab. Exercise 37. Consider the following statements with regard to public interest litigation. 1. In essence, a third party can bring before the courts issue in the public interest. 2. The Supreme Court may act on the receipt of a letter or postcard from a citizen requesting protection of its fundamental rights. 3. It is also known as social action litigation. 4. Justice V.R. Krishna Iyer and P.N. Bhagwati were his proponents. Which of the above are correct? A. 1 and 2, B. 2 and 3, C. 3 and 4, D. 1, 2, 3 and 4. The correct answer is D, that is 1, 2, 3 and 4. 1. In essence, a third party can bring before the courts issue in the public interest. 2. The Supreme Court may act on the receipt of a letter or postcard from a citizen requesting protection of his fundamental rights. 3. It is also known as social action litigation. 4. Justice V.R. Krishna Iyer and P.N. Bhagwati were its proponents. Exercise 38. In which one of the following areas have the reforms been recommended by the Justice Malimat Committee? A. Criminal justice system. B. Civil law. C. Service condition of judges. And D. Administrative laws. The correct answer is A. Criminal justice system. Exercise 39. The system of public interest litigation has been introduced in India. A. Through constitutional amendment. B. By judicial initiative. C. By political parties. D. By a parliamentary act. The correct answer is B. By judicial initiative. Exercise 40. Consider the following statements. 1. The amended Legal Services Authorities Act 1987 stipulates the establishment of permanent Lok Adalats for exercising jurisdiction in respect of disputes relating to some public utility services. 2. Attorney General of India has the right to take part in the proceedings of the Parliament without the right to vote. Which of the statements given above are correct? A. 1 only, B. 2 only, C. both 1 and 2, and D. neither 1 and 2. The correct answer is C, that is both 1 and 2. The amended Legal Services Authorities Act 1987 stipulates the establishment of permanent Lok Adalat for exercising jurisdiction in respect of disputes relating to some public utility services. 2. Attorney General of India has the right to take part in the proceedings of the Parliament without the right to vote. Page 23.11, Chapter 23, the Judiciary in India, the Supreme Court, the High Court, exercises. Exercise number 1, which of the following statements regarding judiciary in India are correct? 1. In India, judiciary is not part of the state. 2. In India, pattern and designation of subordinate courts in the states are not uniform. 3. Munsif's courts have both civil and criminal jurisdiction. 4. The pattern of subordinate courts in metropolitan areas is the same as that in districts. A. 1 and 2, B. 1 and 3, C. 2 and 3, and D. 3 and 4. The correct answer is C, that is 2 and 3. 2. In India, pattern of and designation of subordinate courts in the state are not uniform. 2 and 3. 3. Munsif's courts have both civil and criminal jurisdiction. 2. Which of the following statements regarding the advisors the advisor jurisdiction closed of the Supreme Court are correct? 1. The opinion of the Supreme Court may be sought by the President on any question of law or fact. 2. In case the opinion of the Supreme Court is sought, it is bound to give it. 3. The advice given by the Supreme Court on a matter referred to it is binding on the President since the 42nd Amendment. 4. Advisory jurisdiction of the Supreme Court can also be exercised over disputes arising out of references made over preconditional treaties. A. 1 and 3, B. 2 and 3, C. 1 and 4, D. 1, 2, 3 and 4. The correct answer is C, that is 1 and 4. 1. The opinion of the Supreme Court may be sought by the President on any question of law or fact. 4. Advisory jurisdiction of the Supreme Court can also be exercised over disputes arising out of references made over preconstitutional treaties. Exercise 3. Judicial review in the Indian Constitution is based on A. Procedure established by law, B. Due process of law, C. Rule of law, D. Precedents and conventions. The correct answer is A, that is procedure established by law. Exercise 4. Which of the following is directly related to the appellate jurisdiction of the Supreme Court in India? A. Appeals made in civil, criminal and constitutional cases. B. Appeals made in constitutional cases. C. Adjudication of disputes between the Union and the state. D. Adjudication of disputes between the states. The correct answer is A, that is appeals made in civil, criminal and A. Correct answer is A, appeals made in civil, criminal and constitutional cases. Exercise 5. Which of the following statements regarding the exercise of judicial review in India is not correct? A. A case must be brought before the Supreme Court regarding the validity of a law. B. Unanimous opinion of all the judges is necessary for declaring law null and void. C. Legislative enactments and exclusive orders may be struck down by the Supreme Court. D. The power is implicit in the provisions of Articles 13 of the Constitution. The correct answer is B. Unanimous opinion of all the judges is necessary for declaring a law null and void. Exercise 6. In which of the following categories of cases the Supreme Court of India has the power to decide? 1. A reference made by the President on a question of law or fact. 2. A case involving interpretation of the Constitution. 3. A case involving a substantial quotation of law of general importance. 4. a case where the constitutionality of any law has been challenged. A. 1, 2 and 3, B. 1, 3 and 4, and C. 1, 2 and 4, and D. 2, 3 and 4. The correct answer is D. 2, 3 and 4. 2. A case involving interpretation of the Constitution. 3. A case involving a substantial question of law of general importance. 4. A case where the constitutionality of any law has been challenged. Exercise 7. The writ of prohibition is an order issued by the Supreme Court or High Court which A. affects the subject of production and consumption of liquor. B. prohibits the police from arresting a person. C. forbids the administrative authority from taking a particular action, and D. prohibits a quasi-judicial authority from proceeding with a case. The correct answer is D, that is prohibits a quasi-judicial authority from proceeding with a case. Exercise 23, the judiciary in India, the Supreme Court, the High Court. Exercises, page 23.12. Exercise number 8. Which of the following statements regarding Supreme Courts of India are correct? 1. It has the power to entertain appeal from any court or tribunal within India. 2. It has the power to deliver advisory opinion on question of fact or law referred to it by the President. 3. Salaries of the judges of the Supreme Courts subject to vote by the Parliament. 4. Its jurisdiction is binding on all other courts within India. A. 1 and 3, B. 2 and 4, C. 2, 3 and 4, D. 1, 2 and 4. The correct answer is D, that is 1, 2 and 4. 1. It has power to entertain appeal from any court or tribunal within India. 2. It has the power to deliver advisory opinion on question of fact or law referred to it by the President. 4. Its jurisdiction is binding on all other courts within India. Exercise 9. Consider the following statements regarding the advisory jurisdiction of the Supreme Court. 1. The reference for advice may be made to the Supreme Court on a question of law or fact by the President of India. 2. Disputes arising out of pre-constitution treaties and agreements excluded from the original jurisdiction of the Supreme Court may also be referred to it. 3. The advice given by the Supreme Court is binding on the government. 4. One of the cases referred to the Supreme Court for its advice was the constitutionality of the Kerala Education Bill. Which of the following are correct? A. 1, 2 and 4, B. 2 and 3, C. 1 and 2, and D. 3 and 4. The correct answer is A, that is 1, 2 and 4. 1. The reference for advice may be made to the Supreme Court on a question of law or fact by the President of India. 2. Disputes arising out of pre-constitution treaties and agreements excluded from the original jurisdiction of the Supreme Court may also be referred to it. 4. One of the cases referred to the Supreme Court for its advice was the constitutionality of the Kerala Education Bill. 10. In which of the following cases has the Supreme Court of India laid down that a citizen can be compensated for loss or injury caused by arbitrary or capricious action by a public authority? A. Maneka Gandhi versus Union of India. B. Indra Sahani versus Union of India. C. Common Cause versus Union of India. D. Bandhua Mukti Morcha versus Union of India. The correct answer is C, that is common cause versus Union of India. Exercise 11. How can the number of judges in the Supreme Court in India be increased? A. By President notification. Wrong. A. By presidential notification. B. By a parliamentary act. C. By amendment of the Constitution of India. And D. Representation from the Supreme Court. Correct answer is B, that is by a parliamentary act. Exercise 12. The Supreme Court has the exclusive jurisdiction in regard to A. Constitutional validity of state laws. B. Constitutional validity of concurrent laws. C. Constitutional validity of central law. And D. None of the above. The correct answer is C, constitutional validity of central laws. Exercise 13. Which of the following is not true with regard to the jurisdiction of the Supreme Court? A. Cases relating to disputes between the Union and the states. B. Cases relating to the disputes between the states. C. Cases relating to constitutional validity of the central laws. D. Cases relating to religious matters. The correct answer is D, that is cases relating to religious matters. Exercise 14. Consider the following statements. 1. The Supreme Court of India was established on January 26, 1950. 2. The Supreme Court of India was established on January 28, 1950. 3. Its inauguration took place in the Chamber of Princes. 4. The Supreme Court judges retire at 70. Which of the above are correct? A. 1 and 3, B. 2 and 3, C. 3 and 4, and D. 1 and 4. The correct answer is B, that is 2 and 3. The Supreme Court of India was established on January 28, 1950. 3. Its inauguration took place in the Chamber of Princes. Exercise 15. Consider the following statements with regard to jurisdiction of the Supreme Court of India. 1. It is empowered to issue writs. 2. It has original jurisdiction in regard to the enforcement of fundamental rights. 3. Its appellate jurisdiction can be extended by the Parliament, by the President. 4. It is empowered to punish anyone for contempt of any law. Which of the above are correct? A. 1, 2, 3, B. 1, 2, 4, C. 1, 3, 4, and D. 2, 3, 4. The correct answer is B, that is 1, 2, 4. 1. It is empowered to issue writs. 2. It has original jurisdiction in regard to the enforcement of fundamental rights. And 4. It is empowered to punish anyone for contempt of any law. Page 23.16. Chapter 23. The Judiciary in India, the Supreme Court, the High Court. Exercises. Exercise number 41. Match list 1 with list 2 with regard to the strength of the Supreme Court judges. In the horizontal column, the heads are list 1 and list 2. Under the head list 1, in vertical column, against serial number capital A 1950, against serial number capital B 1956, against serial number capital C 1978, against serial number capital D 1960. I repeat, under list 1 as head, again in the vertical column, against serial number A capital A 1950, serial number capital B 1956, serial number capital C 1978, serial number capital D 1960. Under the head list 2, in the vertical column, against serial number 1 8, serial number 214, serial number 318, and serial number 418. Court. In the horizontal column, the heads are capital A space capital B space capital C space capital D. Under the head capital A, in the vertical column, against serial number A1, B3, C3, D1. Under serial number capital B, in the vertical column, against serial number A3, B1, C2, and D2. Under the head serial number capital C, in the vertical column, against serial number A4, B2, C1 and D3. Under serial number capital D in the vertical column against serial number A2, B4, C4 and D4. The correct answer is A. That is under the head capital A 1950 1, that is 8. Under capital B, under the head capital B 1956 3, that is 11. Under the head capital C 1978 4, that is 18. Under the head capital D 2, under the head capital D, that is 1960 2, that is 14. Which of the following statements is are correct? A1. A Supreme Court judge's service till the age of 65 years. 2. After retirement he can practice only in the Supreme Court. 3. The salaries of the Supreme Court judges is determined by the President. A. Only 1 is true. B. Only 2 is true. C. Only 3 is true. D. 1, 2, 3 are all true. The correct answer is A. Only 1 is true. That is, a Supreme Court judge serves till the age of 65 years. Exercise 43. The required majority for the removal of the Supreme Court judges in each house of the Parliament is A. Majority of the members present and voting. B. Majority of the members of total membership. C. 2/3 majority of the total membership. D. 2/3 majority of the members present and voting. The correct answer is D. 2/3 majority of the members present and voting. Exercise 44. Arrange the following Chief Justices of India in the chronological order. 1. A. N. Rai. 3. K. N. Wanchu. 1. A. N. Rai. 2. S. R. Das. 3. K. N. Wanchu. 4. A. S. Anand. A. 2341. B. 2314. C. 2143 and D. 2413. The correct answer is B. That is 2314. 2. S. R. Das. 3. K. N. Wanchu. 1. A. N. Rai and 4. A. S. Anand. Exercise 45. Arrange the following Chief Justice of India in the chronological order and select the correct order. Code 1. Ranganath Mishra. 2. Meherchand Mahajan. 3. H.G. Kania and 4. B.N. Kirpal. A. 3214. B. 3241. C. 3124 and D. 3142. The correct answer is A. That is 3214. 3. H.J. Kania. Next 2. Meherchand Mahajan. Next 1. Ranganath Mishra. Next 4. B.N. Kirpal. Exercise 46. When sought the opinion of the Supreme Court on the question of law, the courts open before it. 1. May tender the opinion. 2. May refuse to tender its opinion. A. Only 1 is true. B. Only 2 is true. C. 1 and 2 both are true. And D. 1, 2 both are false. The correct answer is 1, 2 both are true. 1. May tender the opinion. 2. May refuse to tender the opinion. Exercise 47. Which of the following does not match? A. Article 131 Original Jurisdiction. B. Article 132 Criminal Appeal. C. Article 129 Contempt of Court. D. Article 136 Special Leave. The correct answer is B. That is Article 132 Criminal Appeal. Exercise 48. Which of the following match? A. Article 133 Constitutional Appeals. B. Article 136 Court of Record. C. Article 143 Civil Appeals. D. Article 137 Review the decision itself. The correct answer is B. That is Article 136 Court of Record. Exercise 49. Match list 1 with list 2. In the horizontal column, the heads are list 1. Under list 1 here, a space list 2. Under list 2, case / event. Under the head list 1 here, in the vertical column, again serial number capital A 1971, serial number capital B 1967, again serial number capital C 1973, again serial number capital D 1980. Under the head list 2 case oblique event, in the vertical column again serial number 1 Minerva Mills case, serial number 2 abolition of privy parts, serial number 3 Goloknath case, serial number 4 Keshavananda Bharati case. Code. In the horizontal column, the heads are capital A space capital B space capital C space capital D. Under the head capital A in the vertical column again serial number A1, B2, C2, D2. Under the head capital B again serial number A2, B1, C3 and D3. Under the head capital C in the vertical column again serial number A3, B3, C4 and D1. Under the serial number capital D in the vertical column again serial number A4, B4, C1 and D4. The correct answer is C. That is under serial number capital A. Capital A means 1971. 2. Abolition of privy parts. Under capital B, that is 1967. 3. That is Goloknath case. Under serial number capital C, that is 1973. 4. That is Keshavananda Bharati case. Under the head capital D, that is 1980. 1. That is Minerva Mills case. Chapter 23, the Judiciary in India, the Supreme Court, the High Court. Exercises, page 23.17. Exercise number 50. The term within invert comma due process of law invert comma clause relates to the following Supreme Court. A. Indian, B. British, C. American and D. Chinese. The correct answer is C. American. Exercise 51. The term within bracket procedure established by law invert comma clause relates to which of the following Supreme Courts? A. American, B. Australian, D. C. Indian and D. Cuban. The correct answer is C, that is Indian. Exercise 52. Which of the high courts has jurisdiction spread over to many states? A. Delhi High Court, B. Guwahati High Court, C. Bombay High Court and C. Allahabad High Court. The correct answer is B, that is Guwahati High Court. Exercise 53. The seat of the Chhattisgarh High Court is A. Ranchi, B. Bilaspur, C. Cuttack and D. Jabalpur. The correct answer is B, that is Bilaspur. Exercise 54. Which of the following high courts is the second oldest in India? A. Calcutta High Court, B. Bombay High Court, C. Madras High Court and D. Allahabad High Court. The correct answer is B, that is Bombay High Court. Exercise 55. Calcutta High Court does not have jurisdiction over which of the following? A. Andaman Nicobar Islands, B. West Bengal, C. Daman and Diu and D. None of the above. The correct answer is C, that is Daman and Diu. Exercise 56. Which union territory has a high court of its own? A. Pondicherry, B. Chandigarh, C. Delhi and D. Lakshadweep. The correct answer is D, Delhi. Exercise 57. Who determines the salaries of the judges of the High Court? A. Parliament, B. State Legislature, C. President and D. Governor of the state. The correct answer is A, that is Parliament. Exercise 58. The family courts decide disputes relating to A. Domestic violence, B. Marriage affairs, C. Property matters and D. Consumers affairs. The correct answer is B, that is marriage affairs. Exercise 59. The first Lok Adalat was held in which year? A. 1985, B. 1986, C. 1987 and D. 1988. The correct answer is B, that is 1986. Exercise 60. Who took interest in the public interest litigation case? A. Bhagwati and Krishnan Iyer, B. Kania and Shastri, C. Ray and Beg and D. Shah and Sikri. The correct answer is A, that is Bhagwati and Krishnan Iyer. Chapter 24, Panchayats, Municipalities, Commissions and Major Issues of Indian Polity. 2. Municipal Bodies. The Parliament enacted the 74th Amendment and added 12th schedule in the Constitution. It relates to the municipal bodies through Articles 243p to 243jd. Article 242p defines municipalities, committees, etc. These articles are being enumerated as follows. 243q, Constitution of Municipalities. There shall be constituted in every state a Nagar Panchayat within bracket by whatever name called bracket closed for a transitional area, that is to say an area in transition from a rural area to an urban area. B. A municipal council for a smaller urban area, and C. A municipal corporation for a larger urban area in accordance with the provisions of this part. 243R. Composition municipalities. 1. Same as provided in clause 2. All the seats in a municipality shall be filled by persons chosen by direct election from the territorial constituencies in the municipal area, and for this purpose each municipal area shall be divided into territorial constituencies to be known as wards. 2. The legislature of a state may by law provide a. For the representation in a municipality of 1. Persons having special knowledge or experience in municipal administration. 2. The members of the House of the People and the members of the Legislative Assembly of the state representing constituencies which comprises wholly or partly the municipal area. 3. The members of the Council of States and the members of the Legislative Council of the state registered as electors within the municipal area. 4. The chairpersons of the committees constituted under clause 5 of Article 243 clause S, provided that the persons referred to in paragraph 1 shall not have the right to vote in the meetings of the municipality. B. The manner of election of the chairperson of a municipality. 243S. Constitution and composition of wards, committees, etc. There shall be constituted wards committees consisting of one or more wards within the territorial area of a municipality having a population of 3 lakhs or more. 2. The legislature of a state may by law make provision with respect to a. the composition and the territorial area of a wards committee, b. the manner in which the seats in a ward committee shall be filled, 3. a member of a municipality representing a ward within the territorial area of the wards committee shall be a member of that committee. 4. Where a ward committee consists of a. one ward, the member representing that ward in the municipality, or b. two or more wards, one of the members representing such wards in the municipality elected by the members of the ward committee shall be the chairperson of that committee. 243T. Reservation of seats. 1. Seats shall be reserved for the scheduled caste and scheduled tribes in every municipality, and the number of seats so reserved shall bear as nearly as may be the same proportion to the total number of seats to be filled by direct election in that municipality, as the population of the scheduled caste and municipal areas or of the scheduled tribes in the municipal area bears to the total population of that area, and such seats may be allotted by rotation to different constituencies in a municipality. Chapter 24, Panchayats, Municipalities, Commissions and Major Issues of Indian Polity. Two municipal bodies, continued, page 24.6. 2. Now, not less than 1/3 of the total number of seats reserved under clause 1 shall be reserved for women belonging to the scheduled caste, or as the case may be, the scheduled tribes. 3. Not less than 1/3 including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes (closed) of the total number of seats to be filled by direct election in every municipality shall be reserved for women, and such seats may be allotted by rotation to different constituencies in a municipality. 4. The offices of chairperson in the municipalities shall be reserved for the scheduled castes and scheduled tribes and women in such manner as the legislature of a state may be law provide. 5. The reservation of seats under clause 1 and 2 and the reservation of offices of chairpersons within bracket other than the reservation of for women bracket close under clause 4 shall cease to have effect on the expiration of the period specified in Article 334. 6. Nothing in this part shall prevent the legislature of a state from making any provision for reservation of seats in any municipality or offices of chairpersons in the municipalities in favor of backward class of citizens. 243U. Duration of municipalities, etc. 1. Every municipality, unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting and no longer, provided that a municipality shall be given a reasonable opportunity of being heard before this dissolution. 2. No amendment of any law for the time being in force shall have the effect of causing dissolution of a municipality at any level, which is functioning immediately before such amendment till the expiration of its duration specified in clause 1. 3. An election to constitute a municipality shall be completed a. Before the expiry of its duration specified in clause 1, b. Before the expiration of a period of 6 months from the date of its resolution, provided that where the remainder of the period for which the dissolved municipality would have continued is less than 6 months. It shall not be necessary to hold any election under this clause for constituting the municipality for such period. 4. A municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued under clause 1 had it not been so dissolved. 243 243B. Disqualifications for membership. 243W. Powers, authority and responsibilities of municipalities, etc. Subject to the provisions of the Constitution, the legislature of a state may by law endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government, and such law may contain provisions for the function as institutions of self-government, and such law may contain provisions for the devolution of powers and responsibilities upon municipalities subject to such conditions as may be specified therein, with respect to 1. The preparation of plans for economic development and social justice. 2. The performance of functions and the implementation of schemes as may be entrusted to them, including those in relation to the matters listed in the 12th schedule. B. The constituencies with such powers and authority as may be necessary to enable them to carry out the responsibilities conferred upon them, including those in relation to the matters listed in the 12th schedule. Chapter 24, Panchayats, Municipalities, Commissions and Major Issues of Indian Polity. 243X. Now, Chapter 24, Panchayats, Municipalities, Commissions and Major Issues of Indian Polity, page 224.7. 2. Municipal bodies, continue. 243X. Power to impose taxes by and funds of municipalities. The legislature of a state may by law a. Authorize a municipality to levy, collect and appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. B. Assign to a municipality such taxes, duties, tolls and fees levied and collected by the state government for such purposes and subject to such conditions and limit. C. Provide for making such grants in aid to the municipalities from the consolidated fund of the state. And D. They provide for constitution of such funds for creating all monies received respectively by or on behalf of the municipalities, and also for the withdrawal of such monies therefrom as may be specified in the law. 243Y. Finance Commission. 1. The Finance Commission constituted under Article 243I shall also review the financial position of the municipalities and make recommendations to the Governor. 2A. The principles which should govern. 1. The distribution between the state and the municipalities of the net proceeds of the taxes, duties, tolls and fees available by the state, which may be divided between them under this part, and the allocation between the municipalities at all levels of their respective shares of such proceeds. 2. The determination of the taxes, duties, tolls and fees which may be assigned to or appropriated by the municipalities. 3. The grants in aid to the municipalities from the consolidated funds of the state. B. The measures needed to improve the financial position of the municipalities. C. Any other matter referred to the Finance Commission by the Governor in the interests of sound finance of the municipalities. 2. The Governor shall cause every recommendation made by the Commission under this article, together with an explanatory memorandum as to the action taken thereon, to be laid before the legislature of the state. 243Z. Audit of the accounts of municipality. 243ZA. Elections to the municipalities. 1. The superintendent's direction control of the preparation of electoral rolls for and the conduct of all elections to the municipalities shall be vested in the State Election Commission referred to in under 243K. 2. Subject to the provisions of this Constitution, the legislature of a state may by law make provision with respect to all matters relating to or in connection with elections to the municipalities. From the above description of the articles, one can describe the organization, functions and other details of the municipal bodies. The Constitution as amended provides for the establishment of Nagar Panchayats for transitional areas, within bracket, that is to say an area in transition from a rural area to an urban area. Municipal councils for smaller urban areas and municipal corporations for larger urban areas. However, no municipality can be constituted in areas that come under the jurisdiction of an industrial establishment that provides or proposes to provide municipal services thereon. Exercise 24. Panchayats, municipalities, commissions and major issues of Indian polity. Municipal bodies continued, page 24.8. All the seats in municipal bodies are filled by persons chosen by direct election from the territorial constituencies in the municipal area. However, the legislature of the state may by law provide for the representation in a municipal body of persons having special knowledge or experience of municipal administration, the members of Rajya Sabha, Lok Sabha and the members of Legislative Council and Legislative Assembly of the state, representing constituencies which comprise wholly or partly the municipal area, and the chairpersons of ward committees. There are wards committee consisting of one or more wards within the territorial area of a municipal body having a population of 3 lakhs or more. The legislature of a state may by law make provisions with respect to the composition and the territorial area of a wards committee and the manner in which the seats in a ward committee are filled. However, the legislature of a state can make provisions for the constitution of other committees in addition to the wards committee. Seats are reserved for the scheduled caste and scheduled tribes in every municipal body in proportion to their population. Out of these reserved seats, within bracket for scheduled caste and scheduled tribes, 1/3 would be reserved for women belonging to these communities. Similarly, not less than 1/3 of the total number of seats to be filled by direct election in every municipal body are reserved for women, within bracket including their reservation in the quota of scheduled castes and scheduled tribes, in bracket closed. Similarly, the offices of chairpersons in the municipal bodies are reserved for the scheduled castes, scheduled tribes and women in such manner as the legislature of the state may by law provide. The legislature of the state may also make provisions for reservation of seats in municipal bodies or offices of chairperson for other backward classes. A person who has attained the age of 21 years is eligible to be elected as a member of a municipal body. The superintendent's direction and control of the preparation of the electoral rolls for and the conduct of all elections to municipal bodies is vested in the State Election Commission, constituted with reference to holding elections for Panchayat Raj institutions. The tenure of every municipal body is 5 years. The municipalities can, however, be dissolved earlier after giving them a reasonable opportunity of being heard. The election of the new municipal body is to be held before the expiry of the tenure or within 6 months of its dissolution, as the case may be. The legislature of the state may extend powers and authority of municipal bodies, if necessary, to enable them to function as institutions of self-government. It may authorize a municipal body to levy, collect and appropriate such taxes, duties, tolls and fees as it thinks fit. It may also assign a share in those taxes, duties, tolls and fees that are levied and collected by the state government itself. It may also make provisions for making grants in aid to municipal bodies from the consolidated fund of the state. It may also provide for constitution of such funds for crediting all money received by the municipal bodies and their withdrawal. The Finance Commission, constituted with reference to Panchayat Raj institutions, is to review the financial position of the municipal bodies and make recommendations to the governor as to the principles which would govern the distribution between the state and the municipal bodies of the net proceeds of the taxes.